ಹಾಸ್ಪಿಟಲ್ ಇತ್ತೀಚಿನ ಕಾಲದಲ್ಲಿ ಜಾಸ್ತಿ ಆಗ್ತಾ ಇದೆ ಅಂತ ನಮಗೆಲ್ಲ
फिर आपके
ಗೊತ್ತಿದೆ.
फ्रेंड्स, क्या आपको लगता है कि
ಇವಾಗಿರೋ
किस पद्धति से ओडिसी
ಸಿಚುವೇಶನ್ಸ್ ಅಲ್ಲಿ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಲಾಸ್ ಬಗ್ಗೆ ತಿಳ್ಕೊಳೋದು ಬಹಳ ಮುಖ್ಯ. ಹಾಗಾಗಿ ಈಗ ನಮ್ಮ ಮುಂದೆ ಇದ್ದಾರೆ ಡಾಕ್ಟರ್ ಶಿವಕುಮಾರ್ ಕುಂಬಾರ್ ಅವರು. ಅವ್ರಿಗೆ ಐ ರಿಯಲಿ ವೆಲ್ಕಮ್ ಸರ್, ಅಂಡ್ ಇಟ್ಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಟಾಪಿಕ್. ಐ ರಿಕ್ವೆಸ್ಟ್ ಆಲ್ ದ ಮೆಂಬರ್ಸ್ ಟು ಯುಟಿಲೈಸ್ ದಿಸ್ ಅಪರ್ಚುನಿಟಿ ಟು ಅಪ್ಗ್ರೇಡ್ ಯುವರ್ ನಾಲೆಡ್ಜ್. ಇವತ್ತು ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಮೊದಲನೇದಾಗಿ ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಪ್ರಾರ್ಥನೆಯೊಂದಿಗೆ ನಾವೆಲ್ಲ ಶುರು ಮಾಡೋಣ. ಎಲ್ಲರೂ ಸಂತೋಷವಾಗಿರಲಿ, ಎಲ್ಲರೂ ಆರೋಗ್ಯವಾಗಿರಲಿ, ಎಲ್ಲರೂ ನೋವಿನಿಂದ ಮುಕ್ತವಾಗಿರಲಿ, ಎಲ್ಲರೂ ದುಃಖದಿಂದ ಮುಕ್ತವಾಗಿರಲಿ, ಎಲ್ಲ ಆಸೆ ಅಂಶಗಳನ್ನು ಮೀರಿ ಗುಣಪಡಿಸುವವರು ನಾವಾಗಿರಲಿ. ಧ್ವಜವಂದನೆ. ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಸದಸ್ಯರಾದ ನಾವು ನಮ್ಮ ರಾಷ್ಟ್ರ ಧ್ವಜಕ್ಕೆ ವಂದನೆ ಸಲ್ಲಿಸಲು ಇಲ್ಲಿ ನಿಂತಿದ್ದೇವೆ. ಅದರ ಗೌರವ ಮತ್ತು ವೈಭವವೇ ನಮ್ಮ ಬೆಳಕು ಮತ್ತು ಶಕ್ತಿ, ಮತ್ತು ಅದರ ಪಥವೇ ನಮ್ಮ ಪಥವು. ಈ ರಾಷ್ಟ್ರೀಯ ಸಂಸ್ಥೆಯ ಮಾನ್ಯತೆ ಪಡೆದ ಸದಸ್ಯರಾದ ನಾವು ನಮ್ಮ ಜವಾಬ್ದಾರಿಗಳನ್ನು ಅರಿಯುವ ಮೂಲಕ ಅದಕ್ಕೆ ನಮ್ಮ ನಿಷ್ಠೆಯನ್ನು ತೋರಿಸುವ ಪ್ರತಿಜ್ಞೆ ಮಾಡುತ್ತಿದ್ದೇವೆ. ದೇಶ ಸಮೂಹಗಳ ನಡುವೆ ನಮ್ಮ ರಾಷ್ಟ್ರಧ್ವಜವು ಉನ್ನತ ಮಟ್ಟದಲ್ಲಿ ಹಾರಾಡುವ ಸಲುವಾಗಿ ನಮ್ಮ ಅಧಿಕಾರದಲ್ಲಿರುವ ಎಲ್ಲವನ್ನೂ ಅದಕ್ಕೆ ಸಮರ್ಪಿಸುವ ಪ್ರಮಾಣ ಮಾಡುತ್ತಿದ್ದೇವೆ. ಜೈ ಹಿಂದ್. IMA ಚಿರಾಯವಾಗಿರಲಿ. ವಂದನೆಗಳು.
I request our chairman of the Public Health Subcommittee, Dr. Kagalkar, to speak few words.
ಎಲ್ಲರಿಗೂ ಶುಭ ಸಂಜೆಯ ವಂದನೆಗಳು. ಇವತ್ತು ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘ ಪಬ್ಲಿಕ್ ಹೆಲ್ತ್ ಕಮಿಟಿ ವತಿಯಿಂದ ನಾವು ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಪ್ರತಿ ತಿಂಗಳ ಅಂತೆ ಇವತ್ತು ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಅತಿ ವಿಶೇಷವಾಗಿ ವಿಶೇಷ ಉಪನ್ಯಾಸಕರಾಗಿ ನಮ್ಮವರಾದಂಥ ಡಾಕ್ಟರ್ ಶಿವಕುಮಾರ್ ಕುಂಬಾರ್ ಅವರು ಇವತ್ತು ಈ ಕಾರ್ಯಕ್ರಮ ನಡೆಸಿಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಅದು ಅತ್ಯಂತ ವಿಶೇಷವಾದದ್ದು. ಮೊಟ್ಟ ಮೊದಲನೇ ಆಗಿ ನಾವು ಈ ಪಬ್ಲಿಕ್ ಹೆಲ್ತ್ ಕಮಿಟಿಯಿಂದ ಮೊದಲನೆಯ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಕೂಡ ಅವರೇ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರು. ಅದಕ್ಕಾಗಿ ಈ ಕಾರ್ಯಕ್ರಮ ನಿರಂತರವಾಗಿ ನಾವು ಪ್ರತಿ ತಿಂಗಳು ವಿಶೇಷವಾಗಿ ನಡೆಸಿಕೊಂಡು ಬರ್ತಾ ಇದ್ದೀವಿ. ಇವತ್ತಿನ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ನಾವು ಮೊದಲೇ ನಾವು ಕೇಳ್ಕೊಂಡಿದ್ದೀವಿ ಈ ಒಂದು ಟಾಪಿಕ್ ಅನ್ನ ಸೆಲೆಕ್ಟ್ ಮಾಡಿ ಈ ಎಲ್ಲ ನಮ್ಮ ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಮೆಂಬರ್ಗಳಿಗೆ, ಸದಸ್ಯರುಗಳಿಗೆ ಮತ್ತು ವಿಶೇಷವಾಗಿ ಈಗ ಹೊಸದಾಗಿ ಏನು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಲಿಕ್ಕೆ ಬರ್ತಾ ಇದ್ದಾರೆ ಎಲ್ಲ ವೈದ್ಯರು, ಯುವ ವೈದ್ಯರು ಅಂಥವರಿಗೆ ವಿಶೇಷವಾಗಿ ಈ ಒಂದು ಲಾಸ್ಗಳ ಬಗ್ಗೆ ನಾಲೆಜ್ ಇರೋದಿಲ್ಲ. ಸೊ ಆ ಒಂದು ನಿಟ್ಟಿನಲ್ಲಿ ಇಂಥ ಕಾರ್ಯಕ್ರಮಗಳು, ಅನೇಕ ಕಾರ್ಯಕ್ರಮಗಳು ಇವತ್ತು CME ಆಗಿರಲಿ, ಅನೇಕ ಕಾನ್ಫರೆನ್ಸ್ ಆಗಿರಲಿ, ಮತ್ತು ಅನೇಕ ಕಡೆ ನಾವು ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘ ಇಂಥ ಕಾರ್ಯಕ್ರಮಗಳನ್ನ ಮೂಡಿಸುವ ಮುಖಾಂತರ ಯುವ ವೈದ್ಯರಿಗೆ ಉತ್ತೇಜನ ಕೊಡಲಿ. ಅವರು ಯಾವುದೇ ಒಂದು ಕ್ರಿಮಿನಲ್ ಲಾಸ್ ಅಂದ ಕೂಡಲೇ ಅವ್ರು ಹಿಂಜರಿಬಾರದು. ಅವರು ಇದರ ಲಾಸ್ ಬಗ್ಗೆ ಅವೇರ್ನೆಸ್ ಆಗಿರಲಿ ಅಂತ ಹೇಳಿ ಇಂಥ ಕಾರ್ಯಕ್ರಮ ಮುಖಾಂತರ ನಾವು ಕೂಡ ಇವತ್ತು ಕ್ರಿಮಿನಲ್ ಲಾಸ್ ಅಂದ್ರೆ ಏನು, ಜೈಲ್ ಅಂತ ಹೇಳಿ ತಿಳ್ಕೊಳ್ತಾರೆ ಎಷ್ಟೋ ವೈದ್ಯರು. ಅದು ಅಲ್ಲ, ಆ ಥರ ಅಲ್ಲ. ಈಗ ನಮಗೆ ಏನದು ಪ್ರೊಟೆಕ್ಷನ್, ಮೆನಿ ಲಾಸ್ ಆರ್ ಪ್ರೊಟೆಕ್ಟಿವ್ ಫಾರ್ ದಿ ಡಾಕ್ಟರ್ಸ್ ಅಂತ ಹೇಳಿ ತಿಳ್ಕೊಬೇಕಾಗಿದೆ. ಇಂಥ ಅನೇಕ ಒಂದು ಅಂಶಗಳನ್ನ ಡಾಕ್ಟರ್ ಶಿವಕುಮಾರ್ ಕುಂಬಾರ್ ಅವರು ನಡೆಸಿಕೊಂಡು ಇವತ್ತು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅವರಿಗೆ ಮಗದೊಮ್ಮೆ ಕಾರ್ಯಕ್ರಮದ ಮುಖಾಂತರ ಅವರಿಗೆ ಸ್ವಾಗತವನ್ನು ಕೋರ್ತೀನಿ. ನಂತರ ರಾಜೇಂದ್ರ ಪ್ರಸಾದ್ ಅವರು ವಿಶೇಷವಾಗಿ ಈಗ ಅವರ ಬಗ್ಗೆ ಒಂದೆರಡು ಮಾತನ್ನ ಹೇಳ್ತಾರೆ. ರಾಜೇಂದ್ರ ಕುಮಾರ್ ಸರ್.
I request our senior vice president, Dr. Marigowda, to inaugurate this program.
ಓ ಸರ್, ನಮಸ್ತೆ. ಎಲ್ಲರಿಗೂ ನಮಸ್ತೆ ಸರ್.
ನಮಸ್ಕಾರ ಸರ್. ನಮಸ್ಕಾರ ಸರ್.
ನಮಸ್ತೆ.
ನಮಸ್ತೆ ಸರ್. ನಮಸ್ತೆ.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ ಸರ್. ರಾಜೇಂದ್ರ ಪ್ರಸಾದ್ ಇದ್ದಾರೆ, ನಮ್ಮ IMA ಸೆಕ್ರೆಟರಿ ಸೂರ್ಯರಾಜ್ ಅವರು ಇದ್ದಾರೆ. ವೆರಿ ಆಕ್ಟಿವ್ ಸೆಕ್ರೆಟರಿ ಸರ್ ನಮ್ಮ IMA ಇದಕ್ಕೆ. ಮತ್ತು ಸುರೇಶ್ ಕಾಗ್ಲಾರ್ ಅವರು ಬಹಳ ಚೆನ್ನಾಗಿ ಅರೇಂಜ್ಮೆಂಟ್, CME ಪ್ರೋಗ್ರಾಮ್ ನ ಚೆನ್ನಾಗಿ ಅರೇಂಜ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಈ ಮೆಡಿಕಲ್ ಲೀಗಲ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ನ ನಮ್ಮ ಶಿವಕುಮಾರ್ ಕುಂಬಾರ್ ಅವರು ಇವತ್ತು CME ಪ್ರೋಗ್ರಾಮ್ ಮುಖಾಂತರ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಇದು ಮೆಡಿಕಲ್ ಲೀಗಲ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಬಹಳ ಇಂಪಾರ್ಟೆಂಟ್. ನಮ್ಮ ಜೂನಿಯರ್ ಡಾಕ್ಟರ್ಸ್ ಕಂತೂ ಬಹಳ ಇಂಪಾರ್ಟೆಂಟ್ ಮೆಡಿಕಲ್ ಲೀಗಲ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್. ಅವರು ಪ್ರಾಕ್ಟಿಕಲ್ ಆಗಿ ಏನು ಅಂತ ಗೊತ್ತಿರೋದು, ಫರೆನ್ಸಿಕ್ ಮೆಡಿಸಿನ್ ಓದಿರ್ತಾರೆ ಅಷ್ಟೇ ಥಿಯರಿನಲ್ಲಿ, ಆದ್ರೆ ಪ್ರಾಕ್ಟಿಕಲ್ ಆಗಿ ಏನು ಅಂತ ಗೊತ್ತಿರೋದಿಲ್ಲ. ಅದನ್ನ ಡೀಟೇಲ್ ಆಗಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಇದು ಒಂದು ಒಳ್ಳೆ ಕಾರ್ಯಕ್ರಮ, ಇದು ಪ್ರತಿ ತಿಂಗಳು ಮಾಡ್ಲಿ ಅಂತ ಹೇಳ್ತಾ ನಮ್ಮ ಡಾಕ್ಟರ್ ಶಿವಕುಮಾರ್ ಕುಂಬಾರ್ ಅವರು ಮಾತಾಡಿ ನಾವು ಕೇಳಿಸ್ಕೊಂಡು ನಾವು ಇದನ್ನ ಸದುಪಯೋಗ ಪಡಿಸ್ಕೊಳ್ಳಿ ಅಂತ ಎಲ್ಲ ಹೇಳ್ತಾ ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮ ಯಶಸ್ವಿ ಆಗ್ಲಿ ಅಂತ ಹೇಳ್ತಾ ನನ್ನ ಎರಡು ಮಾತುಗಳನ್ನ ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ.
ನಮಸ್ಕಾರ ಸರ್.
ನಮಸ್ತೆ.
Sir, I will briefly introduce our guest speaker, Dr. Shivakumar Kumbar. He has done his MBBS, DA, LLB, LLM, MBA, MA, PG, MLS, PG, MLE and CCEPC, IAPC, CDM, FIAMS, Bioethics International Chair, Bioethics Human Rights, and he is Vice President of IMA Karnataka Statement. He was and Chairman of IMA AMS, and he was President of Indian Society of Anesthesiologists, Honorary Professor of IMA National Academy of Medical Specialties, IMA HQ Member of Standing Committee of Legal Cell in 2022, and Headquarters Member Standing Committee for Rural Health in 2021. I request our guest speaker, Dr. Shiv Kumar Kumbar, to go ahead with his talk.
Yeah.
Okay. You can share, sir.
Yeah. Yeah. Can you see my slides?
It's coming, sir. It's coming.
Yes, sir. Now
Now
we can
full screen.
Yeah.
Please make it move.
Yeah. Thank you, in absentia, President Dr. Chinwalar, and Senior Vice President, and Rajendra Prasad, Dynamic Secretary Dr. Suri Raj, and Suresh Kagalkar. Thank you for giving me an opportunity to share a few of my views on a very important topic, but very neglected, I would say, even from the medical fraternity, as well as the judiciary, as well as the police department. Friends, we do come across a lot of cases in medical legal negligence. Mainly, we do come across Consumer Protection Act, criminal laws, and respect to medical council laws. But as everybody knows that last time we touched upon the Consumer Protection Act, which was in 2019. Today, we're going to touch upon the criminal laws in medical profession, which were newly introduced a year ago.
Full screen, madam.
Yeah. Yeah. It is something like a hanging sword on the medical profession. And we are worried about the IPC, CRPC, and the Indian Evidence Act. But aptly, they are amended. BNS, BNSS, and BSA.
Sir, the screen is stuck for us, sir.
Okay, just see. Okay.
Just you can reshare it once.
Now?
No, sir, it is. Now it is gone, sir. You can just reshare once.
Yeah.
Yeah, now it is comes up. Now full screen, sir.
Yeah.
Slide
Okay.
show. Yes, sir. Done, sir.
Yeah. Okay, now you can see. Yeah. Okay. Yeah. BNS 2023 replaced the very old 160 years old colonial era Indian Penal Code, and the new act is effective from 1st July 2024. It is almost structurally similar, yet textually revised. Charges have been incorporated. So, friends, the Indian landscape has undergone a significant reforms and a paradigm shift with the introduction of three key legal codes. One is a Bharatiya Nyaya Sanhita, that is BNS 2023, which old one is IPC, and Bharatiya Nyaya Suraksha Sanhita, we call it as a BNSS 2023. The old one was CRPC, and the Bharatiya Sakshata Abhiniyama, that is BSA 2023, which was called as Old Indian Evidence Act. So you do come across a lot many things. For example, we are doing a DNC, there is a uterine perforation. We are doing a colonoscopy, there is a perforation in the rectum. And such kind of things we do come across, even though you do it in a lawful manner at the utmost care. So ultimately, you are called upon for the criminal expulsion, which you are entitled to have it. So in BNS 2023, the medical professionals are saying doctors be exempted from the criminal prosecution as doctors has no intent to cause harm. Yes, no doubt about it. But the interpretation of the judiciary is something different. Mere absence of intent does not mean one can't be held guilty of criminal negligence. It was debated even in the parliament also. For example, if a car driver rashly drives a car and runs over a pedestrian who loses his life, the driver of the car is held criminally liable for the sections despite having no intent to cause death of the pediatrician. I think everybody will agree on this. So in this sense, the legislature is very skeptical. So they say that providing doctor a complete immunity from criminal prosecution would in effect makes them something different, and they are something like above the law. But legislature instead provided a marginal leniency towards the doctors in BNS Act. So if they give a immunity of this, even though we deal with the life and death of a patient, and other professionals should also demand all over India, so that very skeptical in this, but they have given a, I would say that leniency towards the doctors in BNS. This new BNS has decolonization because it was the 1860 Act in the British era, and it has brought to some justice to the medical profession. And also I would say that it is citizen friendly and doctor friendly to a certain extent. So what are we talking about exactly? This section deals with the causing death by a rash and negligent act. This deals with the causing death by a rash and negligent act. There is no question of this section being applicable in cases of medical negligence where there is damage caused but death has not occurred. Death has occurred. Every death occurring during the medical procedure will not attack this section. The fact that the rash is a negligent act causes death has to be proven beyond doubts in the court of law. To consider medical negligence in this section, requirement of the negligence needs to be satisfied, but it would also need to be gross medical negligence to warrant the criminal charges against the medical professionals. Proving this lies with the prosecution that the patients are attenders who file the complaint in the police station. It is not in the hands of the doctors. It is the negligent people are who are going to allege. They have to prove that the doctors went beyond his capacity or he did something, a gross negligence for which the harm has occurred. The standard for a doctor to be charged under this section have not changed from the previous IPC. So the old IPC 1860 is replaced with the BNS, which I have already told it, and old IPC has 23 chapters. Now this new Act has 20 chapters, and there are 511 sections. Now this has 358 sections. But in reality, what the new provisions have made it? It has not granted any immunity for the doctors from the criminal liability. We have been fighting for many years that decriminalization of the medical profession is the need of the hour, but the legislature did not yield to our demands. Rather, it has given us some changes. In fact, they have become more serious and dangerous to the doctors in day-to-day practice. BNS 1061 deals with the MBBS or those who are registered under the respective medical councils or NMC. If MBBS registered medical practice while performing any medical procedure causes death of any person doing any rash or negligent amounting to culpable homicide, then the said RMP is punishable with the imprisonment of either description of a term which may extend to 2 years and shall also be liable for the fine. Other than MBBS doctors, if there is any rash or negligent act, they are punishable with the 5 years rigorous imprisonment plus the fine. The leniency given to doctors is the imprisonment is 2 years and shall also be liable for the fine. Earlier, 304A IPC, doctors would get away with the imprisonment or fine or both. This has been taken away and punishment is made compulsory in the form of imprisonment as well as the fine. This is very important. But the duration of the imprisonment, that remains the same. 2 years that side, 2 years this new act also. Both jail sentence and fines are mandatory in this act. Then who is the RMP? Who possesses any medical qualification recognized under the NMC 2019 and whose name has been entered in the NMR or state medical register under the act. This clause applies only to the doctors registered under the respective medical council. This provision is applicable for us only, but is not applicable to the eyes doctors or dentists. So, having been said that we have been criminalized unlike other criminals, to a certain extent, that to the 2 years firm. But doctors do protected, are saved with certain immunities, which I am going to tell you. Yes, any act done in good faith, there's a mistake, that's section number 26, they are exempted, there is immunity. Section 18 says that nothing is an offense if it is done by the accident without criminal intention in a lawful manner. Section 19 says that act likely to cause harm done in a good faith to prevent other harms. Section 25 and 26, act done in a good faith for the benefit of the person with a consent. 27 says act done in a good faith for the benefit of the child less than 12 years with the consent of the lawful guardian or the parents. Section 30 says act done in a good faith for the benefit of a person without the consent. And also Section 31, communication in good faith for the benefit of the person. So most of the cases which are being booked, doctors should be well aware of these clauses utilized. Otherwise, you cannot escape. You must be very familiar with this kind of things. That also says the hurt and the grievous hurt which will not cause the death, especially loss of a limb, loss of vision, loss of hearing, disfigurement, any surgical procedure, maybe surgical or plastic surgery, any cosmetic surgery. Section 14 to 18 talks about the hurt and the grievous hurt. The duration of pain in a grievous hurt is reduced to 15 years, which was 20 years in earlier IPC. There is a stringent punishment in a permanent disability or a persistent vegetative state, which I am going to tell you in the next slide. Section 125, endangering life or the personal safety of any person who comes with the healthcare profession. Friends, the BNS 117 and 124, where we can think twice. We don't know how the judiciary or the law enforcing authority will interpret in due course of time. Any act which causes permanent damage or deformity or a vegetative state is punishable with a rigorous imprisonment for 10 years, which may extend to life imprisonment. Friends, we all deal, even though surgical, non-surgical, a patient with a head injury, patient with a meningitis, meningoencephalitis, patients with a sepsis, OP poisonings, who comes to your door or to a clinic or to the nursing home in a gasping state, you have been asked to revive the patient. If you do not revive the patient, it is against the medical ethics or else Hippocratic oath, and also it is against the Supreme Court judgment, that is Paramananda Kataria versus Union of India. If you revive the patient, yes, no doubt you will be very happy. But while reviving the patient, ultimately if the patient goes into the persistent vegetative state, this clause may be applied in due course of time. However, we have an immunity which I have already told. So, having death of the patient in spite of best treatment, you may have a 2 years imprisonment with a fine. We have revived the patient goes into the vegetative state. The judiciary or the enforcing authority may interfere. It is a vegetative state for which the imprisonment 10 years, which may extend to life imprisonment. This is how the judiciary and law enforcement authority interpret. We have to wait and see. However, we have immunity or defenses, which I have already told. What is the relevance of this act? There are some loopholes. I would say that what amounts to gross negligence is not clear in this also. This will target only the registered medical practitioners, but the law never ever talks about the quackery or quacks who get away with most of the cases in their day-to-day practice. And we need to think of a preliminary inquiry, which was there earlier. There is a provision of a deemed section. It means that once the case is filed against the government doctors, they have to take a permission from the government. The government would sanction or it may not sanction permission, or it would delay the inquiry or being given to the government doctors. But if they do not inform the police authority to give a sanction it is deemed, the provision is deemed to be given within 120 days if there is no reply from them. The role of documentation and informed consent is very, very important. Always I say that whatever you document, you intimate, whatever you intimate, you document it. So informed consent, the pros and cons of the surgery, the alternative methods has to be brought to the notice of the patient's relatives, which can definitely save under BNS 106A. We need to have a defensive practice after this. What exactly is meant by defensive practice? There are many people who interpret in some other way, but defensive medicine has become a new need of the hour, especially after the post-BNS implementation. Then what is defensive practice? Practices of recommending tests, procedures, treatments that are not necessarily in the best interest of the patient, but rather serve to protect the doctors from potential litigations. There's a lack of operational clarity in differentiating medical errors from the gross negligence, which inadvertently contribute to the medical practice which have already been done. There are certain tests who may not be required for any of the surgical procedures, but if something goes wrong, you are accountable for that. Why have we not done it? We have no answer. So in these cases, especially handling in the emergencies or high risk cases, doctors have to adopt a defensive medicine even though it is against the ethics of medical practice. Then role of police and FIR under BNS. Currently, there is no legal requirement under BNS that medical board review or expert opinion is obtained before FIR is filed, which is contrary to the Giacometti case, which you have been already talking about. Unfortunately, this judicial directive has not codified in BNS and leaving a room for continued misuse by the judiciary. In fact, in 2024, audit conducted across the 5 major cities in India revealed that 43% of the medical legal FIRs are filed against doctors post BNS. No expert opinion had been sought prior to the police action. This is within a period of 1 year, 2 months of enforcing this law. Then the role of hospital administration and legal influence in post BNS is also very, very important. We must strengthen the institutional protocols to which we have a strong legal scrutiny. For example, as I said, informed consent, documentation, record compliance, pre-litigation preparedness, except to be followed with the SOPs by the hospital authorities. Otherwise, hospital administration shall be responsible. Then comes insurance, indemnity, and financial risk management to the post-BNS. Friends, doctors must proactively adopt robust risk transfer mechanisms through indemnity insurance and institutional legal risk management policies. The best indemnity policy what we have is Indian Medical Association, Professional Protection, Immunity. We need to have it. There is no other go. Sir, ಒಂದು 10 ನಿಮಿಷ ವೇಟ್ ಮಾಡ್ತೀರಿ ಸರ್ ಓಂಕಾರಪ್ಪ. Okay. Yeah, and also it has been brought to everybody notice that which is the best indemnity policy in the private sector. There are a lot of loopholes are there. I advise everybody to go for the IMA Professional Protection Scheme. In 2023, Medical Protection Society of India revealed less than 40% of the private practitioners are aware of this kind of a insurance or indemnity policy, and especially in taluka places and semi-urban areas, nobody has the medical indemnity. I do come across lot many people midnight asking for some queries. When I ask them, any medical indemnity you have, they say that, what does it mean? They say that we have a life insurance policy. Next. Yeah. Okay. No. Back to. ಮುಂದೆ ಹೋಗಿಲ್ಲ ಮುಂದೆ Yeah. There are key difference between the IPC and BNS in medical negligence. Earlier it used to be called as 304A. Now it is section 106(1). And the imprisonment, as I said, remain the same. But here it has come imprisonment with a fine. And the clarity of doctors, there was ambiguity. Now it is more clear. It is a 106(1). How it impacts the healthcare sector? There is a graded penalty for the structure. Section 106 distinguishes between the medical negligence and the general negligence, which I said general negligence, imprisonment of 5 years with a fine, whereas medical negligence is 2 years with a fine. And it has made increased accountability for the medical professionals. It emphasizes both patient protection and the professional responsibility. We cannot get away with the casualty in our day-to-day practice. And also the modernization of the law by outdating a colonial era which was more than 160-170 years old. And patient protection and the rights. Patients have better legal recourse and greater confidence in the judicial system. They also aim to enhance the patient safety by bringing such kind of the acts. And one more thing which I would like to bring to our kind notice, that we talk about the IPC. Now let us deal with the CRPC. What is CRPC? This is nothing but BNSS. It replaces the CRPC and addresses violence against the medical professionals, which was not there earlier. Section 356 makes it an offense to assault or harass medical professionals when he is in line with the duty and may face imprisonment up to 5 years with a hefty fine. The fine is at discretion of the court. This ensures that the doctors can perform duties without fear of retaliation from the aggrieved families. Then this BNSS also streamlines the legal process. To ensure timely justice, BNS introduced fast-track mechanism for violence against the doctors, preventing prolonged legal battles that can discourage doctors from reporting incidents in the violence. It also mandates police authorities to prioritize cases involving the healthcare workers, making it clear that respective states takes the safety of the medical professionals seriously in a lawful manner in the fast-track mechanism, which most of the judiciary and the law enforcement authority may not be knowing. We should bring an awareness to these two law enforcing authorities. Then comes one more. What I said was BSA, which is replaced by the Indian Evidence Act. The admissibility of evidence in the court, expert opinions as testimonies. We have been all dealing with Giacometti case, where expert opinion must be obtained before proceeding against the doctor. In Malay Kumar Ganguly versus Sukumar, court returns the final authority. No expert opinion is required. In Martin D'Souza case, this is what I am talking about, is all Supreme Court judgments. Expert opinion must be obtained before proceeding against the doctors. In Kusum Sharma versus Batra Hospital, expert opinion must be evaluated by the courts. It means to say that they should not depend only upon the expert opinion. In Dr. Anurag Bhushan versus State of Haryana, High Court quashed the proceedings based on the medical board report. So it fully took into account the board's opinion and squashed the FIR against Dr. Anurag Bhushan. One more, Dr. S. Jagan Mehta Reddy, a state of Telangana, expert opinion is a piece of evidence must be corroborative. So it means to say that the courts need not entertain all expert opinion, and they say that expert opinion will just assist to arrive at the verdict of the case. So we should not think that expert opinion is on our favor. So judiciary might interpret in some other way. There are some against expert opinion. They have given their own judgment. So the burden of proof, the onus is on the plaintiff. Patients are the relatives who filed the case to prove that the doctors acted negligently. It provides a safeguard for the doctors, ensuring that they are not presumed guilty until proven otherwise, which is crucial in protecting the doctor from frivolous lawsuits. which was not there earlier. This is also very, very important. Section 200 of the BNS, whoever being in charge of the hospital, it comes to the administration of the hospital or administrator of hospital or superintendent of the hospital, public or private, whether run by a central government, state government, local bodies, any other person for that matter, contravenes the provisions of section 397 of the BNSS shall be punishable with imprisonment for a term which may extend to 1 year or with a fine or both. The one more section, all hospitals run by public, private or central government, state government, any local bodies shall immediately provide the first aid or medical treatment free of cost to the victims of the offences covered under the POSCO Act. And disclosure of the identity of the victim of the sexual offence against a woman and the child shall be punished with a 2 years imprisonment, which is non-bailable. You have to be very, very careful when you are dealing with the POXO cases. There are some sections like section 126, wrongful restraint, 127, wrongful confinement is against the law, for which the section applies imprisonment as well as the fine. Patient cannot be detained on the grounds of a non-payment of the bill, which is clearly mentioned in the BNS. And patient cannot be touched without the consent of the patient, which may be again some sort of a criminal activity against any patient. So there are certain gray areas in this act, which I'm going to tell you. Like preliminary inquiry is a procedural safeguard applicable to medical negligence cases in Jacob Mehta case. The same was upheld in the Lalit Kumar versus State of Uttar Pradesh, which was required for the investigation and registration of the FIR. The purpose of which was to ascertain whether the information issued reveals any cognizable offence or not. But section 173 of BNS, the preliminary conducted where no information pertains to cognizable offence, punishable for 2 to 7 years, there exists a prima facie cause. But the punishment what we are having is 2 years. The cases involving the medical negligence resulting in death of a person are ineligible for the preliminary inquiry, as the punishment under section 106 of the BNS for the registered medical practitioners is 2 years only. This is clearly mentioned in BNS 173, subsection 3. But we have to wait and see how the judiciary, the law enforcing authority will consider it. So there are some confusions. There should be a legislative recommendation for the mandatory expert opinion, at least 2 medical professionals specialized in that field, which has to be considered. We may have to appeal to the legislature. Defense shall be allowed to put forward and submit their opinion to the court of law. The verdict of the medical matter should not be given by non-medical professionals who would not wholly understand the medical facts and intricacies of the medicine. It is injustice for the medical professional to do so. There are some cases which this BNS already applied. In the Ramkumar versus Tagore Medical College and the hospital in Chennai, a patient was given a very common antibiotic, ceftriaxone. The patient went into the anaphylactic shock. They did their best to revive the patient, but they never expected this patient goes on to the anaphylaxis. But in a hurry, they did their best, revived their best. Ultimately, the patient remained vegetative. So the commission awarded 51 lakhs compensation and also 75,000 rupees per month for lifetime towards recurring medical and maintenance charges for the vegetative patients. They also found that the records were fabricated. It was an unfair trade practice. There are a lot of discrepancies and inconsistencies in the records. It means that they never prepared to handle such kind of anaphylactic shock. But you need to be aware such kind of anaphylactic shocks do occur, they would attract such kind of a punishment. This is a recent case where a lady constable who was 33 years old and 32 months of pregnancy, twin rather I would say. And she was admitted in the Banjara Hill Hospital, Hyderabad. And they came to know that one is IUD. And they did a cesarean. The baby was put in the NICU. And the baby who had IUD is given to the father of the child. The father took it for a burial. When the father was in a burial ground, he got a call from the hospital stating that his wife also succumbed post-operatively. The case was filed under BNS 1061 against the gynecologist, hospital, and the staff. PM was done, and the case is under investigation under this BNS Act. And one more woman dies after cesarean section at Belgaum Hospital. It is BIMS. The case is filed again under BNS 106 Section 1. And 3 doctors booked under BNS 106(1), death by negligence at the UP hospital, and hospital sealed immediately. And these are the latest cases. And we have to wait and see. There are a lot many cases in 1 year under the BNS, BNSS, and BSA. And thank you very much for giving an opportunity to share a few of my views about the latest criminal laws against the medical profession.
Thank you, Dr. Shivkumar Kumar. You may start.
Yeah.
Well, I will share a very brief some of the happenings. This is a
Yes, sir.
recent one. Rape survivor bleeds to death. That
Yeah.
is, she's pregnant of 17 years. Abortion pill was given, and the teacher who has raped her was arrested, and also the person who
Yeah.
has given abortion pills, a doctor,
Yeah.
for a criminal abortion, he also should go to jail for
Yeah.
10 years. And High Court directs probe on this death of 65-year-old. That is,
Yeah.
High Court orders FIR be filed for
Yes, sir.
consent was not obtained for a specific surgery. And there is one more case where
Yeah.
34 lakhs for a death delay in
Yeah.
ICU admission. You see, sometimes doctors give a slip so much to be deposited. You see, in emergencies, there is no provision like that. In emergencies,
Yeah, in emergencies, consent may not be required, right?
And so also you should not ask any deposit from the patient. And in forceps delivery, there was some mentally disability of the child, and the gynecologist was asked to pay the compensation of somewhere around 10 lakhs, I think. And Tamil Nadu Consumer Court holds doctor responsible liable.
Yeah, this is Mukesh Yadav.
10 lakh, yes. It
Written
is
this,
partly cutting bile duct while performing surgery to remove the gallbladder. And another case is patient's death after administration of spinal anesthesia. Here the court gives partial, that is remedy, that is bail is given to the doctor.
Correct.
And there is one more case.
Ernakulam,
nerve injury due to negligence, and Consumer Court slabs 3.2 lakhs. And there are many more. Because we are having Karnataka Professional Protection Scheme. Now I request Dr. Madhusudan Kariganur to tell something about Professional Protection Scheme. Dr. Kariganur does not require any introduction. He was our past president and
Chairman of
chairman of IMA KPPS. I think I have got this thing.
Sir, I tried. Kariganur, sir.
Yeah, I am there. One second.
Yes, sir.
Yes, sir.
This is his brief biodata. I will not read it. So I will request Dr. Madhusudan Karignur to take over and talk.
Sir, please, sir.
Sir, biodata in bed, don't worry. Ours is a mutual concept indemnity scheme for the doctors of the IMM, Indian Medical Association members. But I think everybody knows about the professional protection scheme. We
Yeah.
shall have a separate, what do you call, a webinar on these things, because let us focus on the subject of Dr. Shivkumar Kumbar. We shall have a separate this thing on KPPS, because I need lot of discussion and slides to project them, which I am not prepared at present. In brief, this is a mutual concept professional protection scheme.
Yes.
Like this is one of the very least premium indemnity scheme available for the protection of the doctors. We are covering 1 crore, and this year's premium is only 1,900 rupees for 1 crore indemnity. Last month it was last year it was 3,200 because of the GST, and the previous year it was 500 only.
Yes, sir. And
Yeah.
this application and other things, how to access, sir? And also,
Yeah, we have online membership module, which
Yes,
we
sir.
have launched last year on in the month of March. You can go to our website. You just click www.ima.kpps.bengaluru.org. Then you will be directed to get into all the details. We have a very good website. You can go to membership area. You can become the member by just giving 3,700 rupees to the scheme.
Yes,
Then
sir.
every year you will be reminded of your premium in the month of March end, and we give lot of margin for the members to pay till our conference October month.
October.
So that's it. And as far as the talk of Dr. Kumbar is concerned, I think all of us are talking about the negative aspects of the these regulations and acts, or whatever the ಈ ಕಾನೂನೆಲ್ಲವನ್ನ ನಾವು ತುಂಬಾ ನೆಗೆಟಿವ್ ಆಗಿ ಮಾತಾಡ್ತಾ ಇದೀವಿ. Why can't we have the positive aspects of these acts where doctors are protected?
ಹೌದು. ಅದ್ರ
ಅಲ್ವಾ?
ಕುರಿತಾಗಿ ಅವ್ರು ಹೇಳ್ಬೇಕಾಗಿದೆ.
Yes,
Yes, sir.
they have certain immunities. Doctors have a lot of defense, which I said in
ಅಲ್ಲ,
the second or
Sir,
third
Kumar,
slide.
yes, sir.
Yeah, these defense clauses are enough to protect the doctors. But the only thing is, doctors should be made aware of it, and also you should bring to the notice of the law enforcing authority as well as to the judiciary.
Sir, many doctors.
I don't mean that way, but after having
Yeah,
gone
no,
through
yeah,
the after having gone through the
You are right. You have to highlight the way.
yeah, very I think all our what do you call that, ನಮ್ಮ ಕಾನ್ಫಿಡೆನ್ಸ್ ಎಲ್ಲವೂ ಕಮ್ಮಿ ಆಗ್ಬಿಡುತ್ತೆ. ಏನ್ ಮಾಡಿದ್ರು ನಮ್ಮ ಶಿಕ್ಷೆ ಆಗುತ್ತೆ ಅಂತ ಬಂದ್ಬಿಟ್ರೆ,
ಹೌದು ಸರ್. ಸೊ ಅದಕ್ಕೆ
ಅದ್ರ ಬಗ್ಗೆ ಅಲ್ವಾ, ಜಸ್ಟ್ ಅನಾಫಿಲಾಕ್ಸಿಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಸೆಫ್ಟ್ರಿಯಾಕ್ಸೋನ್ಗೆ, ಸೊ ಹೌ ಟು ಟ್ರೀಟ್ ದ ಪೇಷಂಟ್, ಐ ಥಿಂಕ್ ವಿ ಲೂಸ್ ಆಲ್ ಅವರ್ ಕಾನ್ಫಿಡೆನ್ಸ್.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಸರ್, ಈಗ
We need to have
professional.
the court says that yes, when you have a hospital, you should have a emergency drugs should be made available. The staff should be trained for the like handling the like IV line or emergency drugs,
ಅಲ್ಲ, even then also
drugs
would have been tried, sir,
Yes,
because
sir, yes, sir.
when they have
correct.
given IV
oxygen
ceftriaxone,
and
whatever
basic
it is,
things should be there. Even if
Yeah.
they are not there, you need to keep them ready. Yeah.
Yeah,
I
Kumar
think
sir,
we need to
one question.
highlight the
Yes, sir.
I think we need to highlight the positive aspects of the acts like I mean
Expert
what do you call that?
opinion.
Expert opinion ಜೊತೆಗೆ doctors have been saved in lot of cases.
So the doctors, they have done act for the good faith. So many, the sir only told the laws always encourages.
Definitely.
the
This law has
doctors
given a
done
lot
for
of
the good
lenience
faith.
to the doctors.
Yes, sir. Yes, sir. So in that way also we can protect ourselves. And one more thing, sir, any act of this negligency, the doctors has been booked in the FIR without having expert opinion also many times. Even last time also our IMA president went there and solved the problem. So like that, so that is the one fear is there whenever there is a complaint by the attenders. So, so what is your opinion, sir?
The worst case is Archana Sharma's case, where she was booked for murder and she suicided. The police were waiting outside her hospital to arrest her. She was told she has been booked under murder charges and they were waiting for her. Even that police officer has got so much immunity that you cannot remove him from his job. You see, the similar immunity that doctors are not having. That is the problem. In POSCO case also, many doctors are harassed so much. In Pune and Bombay, many doctors have been put in jail for 1 day or so. And only after High Court intervenes, they were left off. That is, you see, it is only because of ignorance. We don't know whether she is pregnant or not, and pregnant when you see the teen pregnancy, it is to be intimated, to whom to intimate, how to intimate and all. Now, of course, all the doctors are aware that the thing is doctors are easy targets for the police to harass either for extraction or for some other reason. That is why it is very much necessary that we should be aware of all these acts and rules and how to follow it. And now we have got our President, Dr. Chinivalar. I request Dr. Chinivalar to speak, and after that we can take a question and answer session.
Yes, sir.
Yes, sir.
Chinivalar.
Sir, muted, sir.
Mute ಆಗಿದೆ. Unmute ಮಾಡಿ.
Hello,
Chirwan
can you
sir,
hear me?
ನಮಸ್ಕಾರ.
ಕೇಳ್ತಾ ಇದೆಯಾ?
Yes, sir. Yes, sir. ಕೇಳ್ತಾ ಇದೆ.
ಸಾರಿ ಫಾರ್ ದ ಲೇಟ್ ಜಾಯ್ನಿಂಗ್. ಅದೆಲ್ಲ ನಾನು ಕೊಪ್ಪಳಕ್ಕೆ ಹೋಗಿದ್ದೆ, ಹೋಗಿ ಬರ್ಬೇಕಾದ್ರೆ ಲೇಟ್ ಆಯ್ತು. ಹಿಂಗಾಗಿ ಐ ರಿಕ್ವೆಸ್ಟೆಡ್ ಸುರೇಶ್ ಕಾಲ್ಕರ್ ಅಂಡ್ ಸೂರ್ಯರಾಜು ಟು ಸ್ಟಾರ್ಟ್ ದಿಸ್ ಒನ್. ಸೊ ಫಾರ್ ಶಿವಕುಮಾರ್ ಕುಂಬಾರ್ ಅವ್ರದ ಏನಂತಲ್ಲ ಈ ಉಪನ್ಯಾಸ ಎಲ್ಲಿ ತನಕ ಆಯ್ತು ಏನೋ ನನಗೆ ಐಡಿಯಾ ಇಲ್ಲ, ಗೊತ್ತಾಗಿಲ್ಲ. ಸೊ ಪ್ಲೀಸ್ already started Kumbhar's this one?
Yes, sir.
Kumbhar start ಮಾಡಿದಿರಾ ಆಗಲೇ?
ಮಾಡಿದೆ ಸರ್.
Finish ಆಯ್ತು ಸರ್. Finish ಆಯ್ತು ಅವಾಗಲೇ.
ಆಯ್ತಾ? ಓಕೆ. ಎನಿವೋ ದಿಸ್ ಏನಂತಲ್ಲ ಮೆಡಿಕಲ್ ಲೀಗಲ್ದು ಏನ ಹ್ಯಾಂಗಿಂಗ್ ಇದಂತ ಏನಂತಲ್ಲ ತೂಗು ಕತ್ತಿ ನೆತ್ತಿಯ ಮೇಲೆ ಅಂತಂದಂಗ ಒಂದು ತೂಗು ಕತ್ತಿ ನೆತ್ತಿಯ ಮೇಲಿದ್ದಾಗ ಏನಂತಲ್ಲ ಎಲ್ಲರೂ ಡಿಫೆನ್ಸಿವ್ ಆಗಿ ಇದು ಮಾಡ್ಬೇಕಂತಲ್ಲ, ಅದೇ ರೀತಿ ಮುಂದಿನ ಯುವ ವೈದ್ಯರು ಏನಂತಲ್ಲ ಯಾವುದೇ ಒಂದು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ರಿಸ್ಕ್ ತಗೊಳ್ಳಾರ್ದಂಗ ಏನಂತಲ್ಲ ಡಿಫೆನ್ಸಿವ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ಕೊಂತ ಹೋಗ್ಬೇಕಾಗ್ತತೆ. ಯಾಕಂದ್ರೆ ನಾವು 80ರಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡುವತ್ನಾಗ ಇಂಥವು ಯಾವ ಇಲ್ದಾಗ ಏನಾದ್ರು ವಿ ಟು ಸೋ ಬೋಲ್ಡ್ ದಟ್ ಏನಂತಲ್ಲ ಯು ಮೈ ನಾಟ್ ಬಿಲೀವ್, ಮನೆಯಲ್ಲೇ ಹಟ್ಸ್ನಲ್ಲೇ ಗುಡಿಸಲುಗಳಲ್ಲೇ ಏನಂತಲ್ಲ ಐ ಡಿಡ್ ಇಂಟರ್ನಲ್ ವರ್ಷನ್ ಆ ಟೈಮ್ನಲ್ಲಿ. ಯಾಕಂದ್ರೆ ಇಂಥವು ಯಾವ ಕಾಯ್ದೆ ಕಾನೂನುಗಳು ಇದ್ದಿಲ್ಲ. ಈ ಕಾಯ್ದೆ ಕಾನೂನುಗಳು ಜಾಸ್ತಿ ಬಂದ ನಂತರ ಏನಂತಲ್ಲ ಭಾಳ ಏನಂತಲ್ಲ ನಾವು ಡಿಫೆನ್ಸಿವ್ ಆಗಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ಬೇಕಾಗ್ತತೆ. ಬಟ್ ಯುವ ವೈದ್ಯರಿಗೂ ಸಹ ಏನಂತಲ್ಲ ಇದು ಒಂದು ಇದು. ಸೊ ಇದರಿಂದ ಯುವ ವೈದ್ಯರಿಗೆ ಶಿವಕುಮಾರ್ ಕುಂಬಾರ್ ಅವರ ಒಂದು ಉಪನ್ಯಾಸದಿಂದ ಏನಂತಲ್ಲ ಇದು ಒಂದು ಒಳ್ಳೆಯ ಮಾಹಿತಿ ಅಭಿಪ್ರಾಯ ಸಿಕ್ಕಿದೆ ಅಂತ ಹೇಳಿ ನಾನು ತಿಳ್ಕೊಂಡಿದ್ದೀನಿ. ಪ್ಲೀಸ್ ಯು ಕ್ಯಾನ್ ಗೋ ಹೆಡ್.
Thank you, sir.
Yes, sir. Thank you, sir. Thank you, sir. Yes, sir. Kumar, sir.
Yes, sir.
Yes, sir. One question, sir. ಈಗ recent ಆಗಿ in a paper news that 3 doctors have been booked for giving a false the report. Especially the physical handicap they are given and MBBS admission also taken place. So there is a lot of the agents are intervened many times and
Yeah.
it happened like that. So what is your answer, sir?
Sir, see, whenever the disability certificate they give it, okay,
Yes,
and we cannot just give like that. The people have come for the, so that we are going to give some benefits to the patient. So once you give a disability certificate, we have to stick on for that.
Yes,
In the
sir.
meantime,
You have to keep a
there
record.
is a board in every, there is a board in every medical college or a district hospital.
Sir, Kumbar sir, you are connected with both the devices, sir. I'll just mute one.
Yeah, one second. Yeah.
Yeah, now you can speak, sir. No, both are muted, sir, now.
No, yeah. See, when you give a certificate, one second, sir. Yeah. See, there are certain criteria. Okay, what is to some we call it the locomotor disabilities, and we have to stick out to that. Just because the patient gets some benefit of it, you cannot give it. And if somebody complains, if they suspect some foul play has been done by giving the disability certificate, they ask you for it has to be done under the chairmanship of the district surgeon, for which you need to address them whether you have given a false or true. If you come to know that they were given a false, probably they will take action on you, no doubt about it. So we have to be very, very careful of late giving the disability certificate. And there is a booklet available by the central government how to issue a not to violate by the registered medical practices. Accordingly, we may have to issue the certificate. Yes.
Yes, sir.
Hello.
Yes, sir. Yes, sir. We are listening, sir. Any questions?
Dr. Shivkumar, sir. Dr. Suriraj here.
Yeah.
Sir,
This is very common, especially with the orthopedic surgeons. Yeah.
Sir, right now, as you told, like BNS, ಮುಂಚೆ IP, Indian Penal Code ಇತ್ತಲ್ಲ ಸರ್, ಇವಾಗ BNS ಅಂತ ಆಗಿದೆಯಲ್ಲ. For the hospitals, we displayed some of the pictures with Indian Penal Code for hospitals ಅಂತ ಹೇಳಿ IPC 353, 504, 506 ಈ ತರ ಹಾಕಿದೀವಲ್ಲ ಸರ್, ಅದನ್ನ ತೆಗೆದ್ಬಿಟ್ಟು BNS ಅಂತ ಹಾಕ್ಬೇಕಾ ಅಥವಾ ಸ್ಟಿಲ್?
ಅದು ತೆಗೆದ್ಬಿಟ್ಟು sir, the proportionate sections are different in BNS. Okay. And IPC section is no more valid from July 1st, 2024.
Okay.
And the parallel numbers, okay, they are there. And there is some modification for that. So you have to put that one. This is the IPC is no more valid now, sir.
Okay.
Yeah.
But what I heard is still this is IPS is Indian Penal Code is still ಅಂತ ಹೇಳಿದ್ರು, ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತಾನೆ ಹೇಳ್ತಿದ್ರು.
No sir. Because the judiciary as well as the police station, they are adopting the BNS. So day for yesterday I happened to meet one district judge. He also said yes, we are following the BNS, BSSS, BSA.
Thank you.
Excuse me, Kumbar sir.
Yes sir.
Dr. Bijna speaking.
Namaskar sir.
Private orthopedic surgeon, whether he is authorized to give disability certificate or not. Private orthopedic surgeon.
No sir, there are two things. See, if the patient has operated on somebody's behalf, you cannot give, sir. Because because in government hospital, orthopedic surgeon also on duty. He come with lot of documents. he has to go through that, he has to intervene it, and he can submit it to the board of disability certificate, he can issue it. But private practitioner on behalf of somebody who has operated somebody, he cannot issue a disability certificate, sir. Unless he treats, unless he operates him.
At
Because
least
he has
it
to give,
should,
depending upon the records available with him, having treated, having undergone a surgery, and what is the disability left. He has to assess it, sir, not on behalf of somebody else, sir.
only treated doctor.
Yes, he only treated doctor.
Yes.
Yeah.
Chat box ನಲ್ಲಿ questions ಇದಾವೆ ಸರ್? Chat box ದಲ್ಲಿ please.
Please. Here, sir, one here.
ರಾಜೇಶ್ ಸರ್ ಹೇಳಿ. ಓಪನ್ ಆಗ್ತಾ ಇದೆ.
Yeah.
Yeah, Dr. Vrinda Kulkarni, please share your thoughts. Kulkarni madam. Chat open ಆಗ್ತಾ ಇಲ್ಲ. Some problem is there.
ಸರ್ ನಮಸ್ಕಾರ ಸರ್, ನಾನು ಡಾಕ್ಟರ್ ವಿಶ್ವನಾಥ್ ಒಂದು ಕ್ವಶನ್ ಕೇಳ್ಬೋದಾ ಸರ್?
ಹೇಳಿ
Yeah,
ಸರ್.
please, Vishwanath.
ಸರ್ ಇದು ಎಮರ್ಜೆನ್ಸಿಯಲ್ಲಿ ಸಪೋಸ್ ಹೈಪಾಕ್ಸಿಕ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬಂದಾಗ ನಾವು ಟ್ರೀಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೂ ಕಷ್ಟ ಆಗುತ್ತೆ. ಟ್ರೀಟ್ ಮಾಡಿ ಹೈಪಾಕ್ಸಿಕ್ ಡ್ಯಾಮೇಜ್ ಆಗಿ ವೆಜಿಟೇಟಿವ್ ಸ್ಟೇಟ್ ಅಲ್ಲಿ ಆದ್ರೂ ನಮ್ದು ಕಷ್ಟ ಆಗುತ್ತೆ. ಈ ಒಂದು ಲಾನ ನಾವು ಏನಾರ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು ಅಥವಾ ಏನಾದ್ರು ಇದ್ರ ಬದಲಾವಣೆ ಮಾಡ್ಬೇಕಂತ ಐಎಂಎಯಿಂದ ಏನಾದ್ರು ಮಾಡ್ಬೋದಾ? ಏನ್ ಮಾಡಕ್ ಸಾಧ್ಯ ಇದೆ ಸರ್?
No, sir, this is a central law already implemented at the central government level. And whenever you treat such kind of a patient who comes in a hypoxia, even in spite of being treated, he remains to be in a hypoxia state. Okay. So there are certain sections who can definitely protect the treating doctor. For example, section 26, the act done in a good faith. Okay. The other section 19, act likely to be done in a good faith to prevent further harm. Okay. So the BNS section 26, 18, 19, 25, 27, 30, these are the immunities given to the doctors who comes across such kind of emergencies, sir.
ಬಟ್ ಇದನ್ನ ಯಾವ ರೀತಿನೂ ನಾವು ಚೇಂಜ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಸರ್. ಯಾವುದೇ ನಮ್ಮ ಡಿಸ್ಕಷನ್ ಆಯ್ತು, ಮಿನಿಸ್ಟ್ರಿಗೆ ಡಿಸ್ಕಷನ್ ಆಯ್ತು, ಎಲ್ಲೂ ಏನೂ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ ಸರ್, ಚೇಂಜ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ.
Illa, sir, it is just like a PCPNDT Act where you cannot even change or put a comma in the act. So
Yes,
the
sir.
same thing holds good with this because it's a central government act.
Central Government Act.
But definitely the law has given a lot of immunities. Okay. So negligence is a gross negligence is reckless act by the doctor in his profession. The imprisonment is 2 years only. If the same act is done by other people, apart from the registered medical practitioner, the imprisonment is 5 years. Otherwise, it would have been remained same even for the registered medical practitioners. But the law has given us some immunity for us to look into the matter. So that is only the 2 years. But the added thing is, we cannot get away without a fine also. So imprisonment per the and the fine. Whereas in the previous act, there is only imprisonment or fine or both. But here, both have made it as a mandatory. This is probably, I would say, very sorry for this.
Yes.
Yeah.
ಯಾಕಂದ್ರೆ ಸರ್ ಹೈಪಾಕ್ಸಿಕ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬಂದಾಗ ಡಾಕ್ಟರ್ 5 minutes ಹೋಗೋಕೆ ಲೇಟ್ ಆದ್ರೂ ಸಹಿತ ಅಷ್ಟು ಟೈಮ್ ತಗೊಂಡ್ರು ಸಹಿತ ಅದು ನೆಗ್ಲಿಜೆನ್ಸ್ ಅಂತಾಗಿ ಪ್ರೂವ್ ಮಾಡ್ಬೋದು ಅವರು. 5 minutes ಲೇಟ್ ಆಗಿ ಬಂದ್ರು ಅಂತ.
No, sir. Doctors should be made available within a reasonable time. So they have not defined what exactly is the reasonable time. But to the best of anybody's knowledge, reasonable time means 5-10 minutes or 15 minutes he has gone out for a food, he has gone for some meeting. In the meantime, when you have put a hospital, the patient has come with the confess that I get some remedy in the hospital people can start the treatment till you come. If you are quite like delayed, if you know that probably you will not be able to attend it, probably ask the staff to do the first aid treatment and refer them to the best of their ability to the further hospital. ಈಗ ಬಹಳ ಜನ ಹೆಂಗ ಸರ್ ಎಲ್ಲೋ ಮೀಟಿಂಗ್ ನಾಗ ಕಾನ್ಫರೆನ್ಸ್ ಇರ್ತಾವ ಡೆಲಿವರಿ ಪೇಷಂಟ್ ಬಂದಿರ್ತದ. So they start telling on the telephone that they give the start the drip, start this thing, everything. Ultimately, they come up with the IUD or a severe fetal distress baby. So that time the question arises: how did you inform your staff on phone? How did the staff started telephonically with your treatment? These are two reasons wherein you are dragged into the court of law, stating that there was a clear-cut negligence on the part of a doctor because he would have said, no, I'm not available. But in spite of that, he told on phone, and probably this how the things will happen.
Okay, sir.
ನಮಸ್ತೆ ಸರ್, ನಾನು ಡಾಕ್ಟರ್ ಸೋನಿಯಾ ಮಂದಪ್ಪ ಅಂತ ಮೈಸೂರಿಂದ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ. ಸರ್, ಇದೇ ಕಾಂಟೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಐ ಆಮ್ ಆಲ್ಸೋ ಗೈನಕ್ ಆಬ್ಸ್ಟಿಟಿಷಿಯನ್ ಪ್ರಾಕ್ಟಿಸಿಂಗ್ ಇನ್ ಮೈಸೂರು ಸಿಟಿ. ಸರ್, ನಾನು ಇದನ್ನೇ ಕಾಂಟೆಕ್ಸ್ಟ್ ಮುಂದುವರ್ಸೋಣ ಅಂತ ಅನ್ಕೊಂಡಿದ್ದೆ. ಸಪೋಸ್ ಎನಿ ಟೈಮ್ ಇನ್ ಲೇಬರ್ ಅವ್ರು ಬರ್ತಾರೆ, ಫುಲ್ ಡಯಲ್ಟಿಷಿಯನ್ ಅಲ್ಲಿ ಬರ್ಬೋದು. ಅವಾಗ ನಮಗೆ ಆ ಟೈಮಲ್ಲಿ ಆ ಪರಿಸ್ಥಿತಿಲಿ ನಾವು ಪೇಷಂಟ್ನ ಅಟೆಂಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಸೊ ಇದೇ ಕಾರಣಕ್ಕೆ ನಾವು ಫಾಕ್ಸಿ ಫೆಡರೇಷನ್ ಆಫ್ ಆಬ್ಸ್ಟೆಟಿಕ್ ಅಂಡ್ ಗೈನಕ್ ಸೊಸೈಟಿ ಅವರು ನಾವು ಟೋಟಲ್ ಆಗಿ ನರ್ಸಿಂಗ್ ಫ್ಯಾಕಲ್ಟಿನ ನಾವು ಟ್ರೈನ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಸೊ ಅಲ್ಲಿ ಮಾನ್ಯತೆ ಅಕ್ರಿಡೇಟೆಡ್ ಹಾಸ್ಪಿಟಲ್ ಅಂತ ನಾವು ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಅವ್ರಿಗೆ ಆ ಟ್ರೈನ್ ಆದ ನರ್ಸ್ಗಳು ಅವರು ಅಕಸ್ಮಾತ್ ಹ್ಯಾಂಡಲ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ನಾವು ಹೋಗಿ ತಲುಪೋ ತನಕ ಅಂದರೆ ಆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಪ್ರೋಸೆಸ್ಸಲ್ಲಿ ವಿ ಆರ್ ನಾಟ್ ಪ್ರೂವ್ಡ್ ನೆಗ್ಲಿಜೆಂಟ್. ಸೊ ಇದು ನಮ್ಗೆ ಅರ್ಥ ಆಗಿರೋದು ಸರ್. ನಾವು ಮೆಡಿಕಲ್ ಆ ಟೈಮಲ್ಲಿ ಇಲ್ಲದೆ ಇದ್ದಾಗಲೂ ಆ ಮೆಡಿಕಲ್ ಏಡ್ ನಮ್ಮ ಪರವಾಗಿ ಟ್ರೈನ್ಡ್ ಸ್ಟಾಫ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ನಾವು ಟ್ರೈನ್ ಸ್ಟಾಫ್ ಅಂತ ಅವ್ರನ್ನ ಪ್ರೂವ್ ಮಾಡಿದಾಗ ಈ BNS ಐ ಥಿಂಕ್ ಯಾರೋ ಒಬ್ರು ಹೇಳಿದ್ರು, ವಾಟ್ ಈಸ್ ದ ಡಿಫ್ರೆನ್ಸ್? ಸೊ ಅಟ್ ಲೀಸ್ಟ್ ನಮಗೆ ಇದರಲ್ಲಿ ಪಾಸಿಟಿವ್ ಏನಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಸೆಕ್ಷನ್ 1825(20) ವಿ ಕ್ಯಾನ್ ಪ್ರೂವ್ ದಟ್ ವಿ ವರ್ ನಾಟ್ ನೆಗ್ಲಿಜೆಂಟ್. We tried to give a medical assistant from an authorized medical assistant who was there, either a duty doctor or a nursing staff trained at that particular time. So adu namge ಸ್ವಲ್ಪ mileage kottide anta ansutte alla sir, if I am not wrong.
The law does not require a qualified person in these cases, a trained and expertise person. You must prove in the court of law if it all comes. Okay, how did you qualify? How did you quantify that the staff has expertise? You would say that they have undergone a basic BNS training or a research training. Okay, a BLS training.
Correct.
And she has expertise and skill. She is trained under me. She has attended so much BLS this thing. Yes, definitely. The law requires the expertise, not the qualification in this matter.
ಸರ್, ಆಮೇಲೆ ಈ ಬಿಲ್ ಪೇಮೆಂಟ್ ವಿಷಯ ಹೇಳಿದ್ರಲ್ಲ ಸರ್, ನಾವು ಫೋರ್ಸ್ ಬಿಲ್ ಪೇ ಮಾಡದೆ ಅವರು ಹಾಸ್ಪಿಟಲ್ ಇಂದ ಹೋಗೋ ವಿಷಯ. ಬಟ್ ಬಿಲ್ ಪೇ ಮಾಡದೆ ನಾವು ಅದು ಸಾಕಷ್ಟು ಸಮಯ ಹಂಗಾಗುತ್ತಲ್ವಾ ಸರ್? ಸೊ ವಾಟ್ ಡಸ್ ಯೋರ್ ಟೇಕ್ ಆನ್ ದಟ್ ಸರ್? ಬಿಕಾಸ್ ಒನ್ ಆಫ್ ಯೋರ್ ಸ್ಲೈಡ್ ಸೆಡ್ you should not stop them if they are paying.
No, I'll tell you. See, here the communication skill matters a lot here.
Correct.
The law says that, and for example, ಕೆಲವೊಂದು ಲಾವಣಗ ಪೇಷಂಟ್ ಡೆತ್ ಆತಪ್ಪ ಅಂತಂದ್ರೆ, ಓಕೆ, ಡೋಂಟ್ ಸಿ ಹಂಗೆ ನೀವು ಬಿಲ್ ತಗೊಳ್ತಂದ್ರೆ ಹೌ ಡು ಯು ರನ್ ದಿ ಹಾಸ್ಪಿಟಲ್? ನೀವು ವಾರದಾಗ ಒಂದು ಪೇಷಂಟ್ ಡೆತ್ ಆಗ್ತಂದ್ರೆ ಎಲ್ಲರೂ ಓವರ್ ಹೆಡ್ ಬರ್ಡನ್ ಇದ್ದಾಗ ದೇ ಹ್ಯಾವ್ ಟು ಕ್ಲೋಸ್ ಹಾಸ್ಪಿಟಲ್. ಸೊ ವಾಟ್ ದ ಲಾ ಸೇಸ್ ದಟ್ ಯು ಹ್ಯಾವ್ ಟು ಎಕ್ಸರ್ಸೈಸ್ ಯುವರ್ ಡ್ಯೂ ಕಾಶಿಯಸ್ in taking the bills in advance. There's nothing wrong in taking the advance bill. ಎಲ್ಲ ಒಂದು ಹಾಸ್ಪಿಟಲ್ಗೆ ಏನು ಮಾಡ್ತಾರೆ ಗೊತ್ತಾ ಮೇಡಮ್? ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ they anticipate about 15 days hospital stay when the patient goes into a cesarean or hysterectomy. Advance bill ತಗೊಳ್ತಾರೆ. 3 days 4 days ಆದ್ಮೇಲೆ again they take an advance. ಅದು ಆಗದೆ ಇದ್ರೆ probably they think that probably patient may not pay. You take a post-it check from him. Okay, and if ಅದು honor ಆಗಲಿಲ್ಲ ಅಂತಂದ್ರೆ, yes, definitely you can file a civil lawsuit to recovery of the bill, even more on that, even including the legal fees. So there is a communication skill matters, and maybe once in a blue moon it can happen, but you may have to take it as a social responsibility. That's it.
ಸರಿ, BNS ಭಾರತೀಯ ನ್ಯಾಯ ಸಂಹಿತೆ ಅದು ನಮ್ಗೆ ಆಯುಷ್ ಡಾಕ್ಟರ್ಸ್ಗೆ ಅಪ್ಲೈ ಆಗ್ತಾ ಇಲ್ವಾ ಸರ್? ಡೆಂಟಿಸ್ಟ್ ಆಯುಷ್ಗೆ?
There are two things, madam. See, they don't come under the registered medical practitioners. If negligence has taken place by them, okay, apart from the allopathic doctors, the imprisonment is straightway 5 years with a fine. Straightway. Ayush, dentist, anybody for that matter other than the registered medical practitioners.
Because ಬಹಳಷ್ಟು ನರ್ಸಿಂಗ್ ಹೋಮ್ಸ್ ಅಲ್ಲಿ ಆಯುಷ್ ಡಾಕ್ಟರ್ಸ್ ಡ್ಯೂಟಿ ಡಾಕ್ಟರ್ಸ್ ಅಲ್ಲ ಸರ್, ಸುಮಾರು ಕಡೆ ಅವರೇ ಇದಾರಲ್ಲ.
No doubt about it, madam. But ಏನಾಗ್ತದೆ ಮೇಡಮ್, ಅವ್ರ ಮಿಸ್ಟೇಕ್ ಅನ್ಸುತ್ತೆ. The attending cardiologist are responsible. Not only those, the hospital owner is also responsible for that. The vicarious liability falls even on them also.
Correct, sir.
Yeah.
Thank you so much, sir.
Okay.
Dr. Brinda, you can unmute and talk.
Yeah, thank you. That was my question in the chat box. So if the cases are filed before July 1st, 2024, will BNS apply or IPC apply?
No, IPC will apply, madam.
That's what I thought.
Yeah,
Okay.
IPC will
Thank
apply.
you. Thank you for clarifying.
Yeah. On or before July 1st, 2024, okay, IPC will apply, madam.
Yes, thank you.
Sir, Kumar sir, this
Sir.
is Dr. Madhusudan.
Yes, sir.
Sir, after listening all these things,
Yeah.
when I went through the cases of the KPPS,
okay,
see, law is for the doctors. What I feel.
No doubt.
Yeah, it is for the doctors. Let us not be get scared by all these acts. ಇವೆಲ್ಲ ಏನೇನಿದಾವೆ ಮೈನ್ಯೂಟ್ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ ನೋಡ್ಕೊಂಡು ನಾವು ಹೆದರ್ಕೊಳ್ಳೋದು, ನಮ್ಮ ಪ್ರಾಕ್ಟೀಸ್ ಬ್ಯೂಟಿಯನ್ನ ಬಿಡತಕ್ಕಂಥದ್ದು ಬೇಕಾಗಿಲ್ಲ. Let us not be scared by all these things, because
definitely
when I kindly let me finish. See, when I went through all the cases, we lose the cases because of the wrong arguments and wrong evidences and wrong documentations. You would have done all the things best of your knowledge, best of your ability. Even advocates are also, I mean, judges, they are with the doctors. They understand the status of the doctors, of treating doctors. ಅದು ಅವ್ರಿಗೆ ಗೊತ್ತಿರುತ್ತೆ. ಬಟ್ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಕೆಲವು ಸಲ ತುಂಬಾ ಗ್ರಾಸ್ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದಾಗ ಮಾತ್ರ ಈ ರೀತಿ ಆಗ್ತಕ್ಕಂಥ ಪನಿಷ್ಮೆಂಟ್ಸ್ ಇರ್ತವೆ. ಅಷ್ಟು ಬಿಟ್ರೆ ಅನೆಕ್ಡೋಟಲ್ ಕೇಸಸ್ ಅಲ್ಲಿ ಕೆಲವು ರಾಂಗ್ ಆದಾಗ ವಿ ಹ್ಯಾವ್ ಡೆಫಿನೆಟ್ಲಿ upper house to argue. Am I right?
Yeah, I do agree with you. As you rightly said, only the documentation makes the difference. And how you plead in, what you give inputs to the advocates to argue in the court of law, that also matters. Because advocates, however the expert they are, they may not be knowing the intricacies of what the medical terminology is there. So we have to give, as you rightly said, we have to give a solid inputs to the advocates to argue on behalf, and also the documentation means a lot, especially in the medical legal cases, either it's a consumer case or in the criminal cases. I agree with you, Madhu.
Yes, sir. Documentation is important, sir. And how many years we have to keep such documents? 10 years? 5 years?
No. See, when it comes to the Consumer Protection Act, it has not changed. It is only the 2 years. But however, the president of the consumer has a lenience. If the complainant would convince that I did not file case before 2 years, if the judges agree for that, we call it as a condonation of the delay, even after 3 years or 4 years. But in criminal cases, when the case is filed, you have to preserve the case paper till the dismissal of the case. But for all practical purposes, I advise everybody, indoor patients has to be kept for 5 years. Once it's a MLC, it has to be kept till dismissal of the case.
Sir, Shivkumar sir, one question. Any existing laws to give immunity for arresting a doctor in some certain situations like on-table death?
Yeah.
Like that, sir.
Sir, on-table death need not be a medical legal case.
Yes, sir.
For example, unexpected on-table death, either because of the anesthetic cause or surgical causes or the hospital infrastructure causes, we have to inform the police, and it's the police responsibility to take the charge or custody of the on-table death body, and will investigate as per the law enforcing authority. But if the expected death has occurred, where you know the cause of death, you can as well give a cause of death without any hesitation, because you know the cause of death. But the cause of death has to be accepted by the patient relatives. If they don't accept the cause of death what you have given, they can file a complaint, and here to substantiate in the court of law the cause of death, you should have arrived at the cause of death before giving the certificate of cause of death. Either it may be because of the invasive investigations or non-invasive investigations or the ECG, echo, whatever it is. Okay. So these are the two things. All on-table death need not be made it as a medical legal case, sir. Definitely there are some immunities even in the on-table death. For example, BNS, I told you, section 26, 24, 25, they all come under the defensive practice, especially in the surgical or anesthetic tables.
In such situations, it is always better to take help from the lawyer, sir.
Yes, sir. We have to take a.
Two things, sir.
Kumar sir is
See,
there.
only 4 people. Okay.
Yes, sir.
And you should be able to convince the law enforcing authority what best you have done to save the life of the patient. So if you take the help of the lawyer, it will not help because the clause is available, and even if the lawyer comes, he will get the bill for you. There is no reason for you to get the bill because it's already available. In the last year, one of the lawyer in Hubli, the dentist, okay, he had some problem and immediately he arrested him. Then I called him. The police inspector there, no sir, why have you arrested him? It's available. Even his father, his wife can give a surety and get away. It's available. Then he argued with me. Ultimately, I sent him Supreme Court judgment within 5 minutes, and he released him on bail.
Yes, sir.
What is that Supreme Court judgment, sir? Because every doctor and every hospital should keep them copy on
Yes,
table.
Yes, sir.
These
Also, I have to
things
display
are
our-
unexpected most of the time. ಒಂದೊಂದು ಕಾಪಿ ಇಟ್ಕೊಂಡ್ರೆ ಒಳ್ಳೇದಲ್ಲ ಸರ್ ಟೇಬಲ್ ಮೇಲೆ.
ಒಳ್ಳೇದು ಸರ್, ಒಳ್ಳೇದು.
ಅಲ್ಲ ಈಗ ಎಲ್ಲ ಹಾಸ್ಪಿಟಲ್ ವಾಟ್ ವಿ ಹ್ಯಾವ್ ಡಿಸ್ಪ್ಲೇಡ್ ಸರ್ ದಟ್ ಬೋರ್ಡ್ ಹ್ಯಾವಿಂಗ್ ದಿಸ್ IP section. Shall we replace and something like BNS for all the hospital?
Yes, definitely. The IPC we have to take away and put it in a BNS, sir.
BNS and certain acts.
Yeah.
ಶಿವಕುಮಾರ್
Sir.
Yes, sir.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಅದು ಹೇಳಿದ್ರಲ್ಲ ಜಜ್ಮೆಂಟ್ ಅದು Can you put it in the IMA KSB group?
Yeah, I will, sir. I'll put it.
Can share it so that
I'll share
everyone can keep it.
Yeah. They can take
Yeah,
a
this
printout of it and at least keep it in the PDF format and give it. Okay.
PDF ಫಾರ್ಮದಲ್ಲಿ
Yes,
ಆಯ್ತು
sir.
ಅಂದ್ರೆ
Yes, sir. I'll do it.
ಸರ್ ಇನ್ನೊಂದು ಹಾಸ್ಪಿಟಲ್ ಡಿಸ್ಪ್ಲೇ ಮಾಡೋಕೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋ ಅದನ್ನು ಗ್ರೂಪ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ ನಾವು ಇಲ್ಲಿ ಪ್ರಿಂಟ್ ಮಾಡಿ ಡಿಸ್ಪ್ಲೇ ಮಾಡಬಹುದು.
ಅದು ಮಾಡ್ತೇನೆ sir. I will do it, sir. In 2-3 days I will do it. What is to be displayed in the respect to Nursing Home and Hospital, and
Yes, sir.
what are the Supreme Court judgments where doctor can be defended, okay, where he has got immunity for that, I'll put it in the group.
Thank you, sir.
Okay.
ಅಲ್ಲ ಈಗ ಕುಂಬಾರ್ ಸರ್
ಹೇಳ್ರಿ.
ಈಗ ಫಾರ್ ಸಚ್ ಮೆನಿ the issues and complaints, is there any toll-free number by IMA medical legal group, something like that, so that
Toll-free number
regarding any issues or to whom to contact, so like Dr. Kumbar sir is there.
No. See, I think Madhusudan is the best person for that because
Yes,
we don't have a medical legal cell in IMA KSB, okay, and as you read this issue, I think probably Chinimal sir can take an issue.
Chinimal sir,
and before his tenure over or the next president comes, okay, he can put 1 or 2 like those who are well versed in the law and other things. Okay, anytime they can become, because I get at least 1 or 2 calls in a 3 or 4 calls in a month. Okay, and late 2 o'clock, 3 o'clock, something has happened, sir. Ambulance is not available. What is to be done? Death has occurred. What to be done? Hypertension has occurred. I was shifting the patient to the tertiary care center, district hospital. On the way, patient died. So I get at least 3-4 calls in a month. Probably a helpline number like that where they can get the instant remedy. Okay, so that can be a worthwhile, sir.
Yes,
I think Chinwal sir can think of it.
I think it is very important to display all the
Yes, sir.
existing BNS laws in front of hospitals, sir.
Yes, sir.
That will save us during emergency crisis.
I think there are no more questions.
I think we can conclude, sir.
Okay, sir.
Anuradha madam idara? Anuradha madam ಇಲ್ಲ.
Anuradha ಇಲ್ಲ.
Okay.
ಸರ್ ಮಾತಾಡ್ಬೋದಾ?
ಮಾತಾಡಿ.
ಕುಂಬಾರ್ ಸರ್ ತುಂಬಾ ಚೆನ್ನಾಗಿ ಮಾತಾಡಿದ್ರು, ಮತ್ತೆ ಚೆನ್ನಾಗಿ ನಮಗೆ ಮನವರಿಕೆ ಮಾಡ್ಕೊಟ್ರು. ಮಾಡೋ ಕೆಲ್ಸನ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ಬೇಕು ನಾವು. ಆಮೇಲೆ ನಮ್ಮ ಕಾರಗ್ನೂರ್ ಸರ್ ಅವರು ತುಂಬಾ ಚೆನ್ನಾಗಿ ಪ್ರತಿಯೊಬ್ಬರಿಗೂ ಪ್ರೊಫೆಷನಲ್ ಇಂಡೆಮಿನಿಟಿ ಅಗತ್ಯ ಇದೆ ಅಂತ. ಆಸ್ ಡಾಕ್ಟರ್ ಶಿವಕುಮಾರ್ put it, whenever somebody has a problem, when you ask a question whether they have professional indemnity, as he rightly put it, most of them don't know, and most of them do not have professional indemnity at all. So
Correct.
my few messages to my colleagues is, any doctor whom you and me bump into, let us take some time out and make them aware that they have to make sure that they have professional indemnity. That's one message I would like to give. Second thing is, whenever we have any difficulty managing our cases, we also need to have some of our colleagues as our godfathers or godbrothers, whomever you call, discuss the case with them. And if you feel that they are potential litigants, we can always take help from our colleagues to find out how better to be comfortable, in the sense that we should not have peaceless nights. We should be very comfortable. This is one message. And the third very important message, Dr. Kumar, I would like to say is, only some of our professional colleagues have taken up law, and you know very well about how to manage the case. But if in case by default we hand over the case to a non-doctor advocate, A to Z, you need to appraise them. You need to explain everything to them. They don't know anything. They don't know anything. So we have to, A to Z, you have to sit and explain to them. Only that part they will be able to speak
they
in
would
court.
spoil the case. They would spoil the
They'll
case in due
spoil
course
the
of time.
case. Yes,
Because-
they'll spoil the case. So
I had a
we-
case. I had a
Yes.
case, a criminal case, couple of years back. He had given a consumer advocate, and he realized only when the police came to arrest him, arrest warrant. He thought that probably, sir, our other good, they will take care, because he was a consumer advocate and he never ever bothered about this criminal intention or the criminal clauses. That's what has happened, madam.
Yes, and medical knowledge.
And definitely the advocates do not know anything about the case at all. You are only, if you are good enough to take your time out and sit and explain the case to them, then they will be able to speak on your behalf. And much more than that, we have enough of our qualified doctors who have taken up law, and they are always there with us to guide us, to support us, and to fight our cases by default, if in case, touch wood, if something goes wrong. So Dr. Suresh, Dr. Rajendra Prasad, all of us, let us struggle a little more and see that many more of our doctors take up professional indemnity. That question needs to be asked to every other, colleague that we meet. Thank you.
Thank you, madam. Thank you.
We'll conclude.
Yes, sir.
Yes, sir.
Yeah, Raj. Yes, sir.
Sir, it was a wonderful presentation. I thank Dr. Shiv Kumar Kumbar for a wonderful presentation, and my thanks to our President, Dr. Chiniwala, and our Secretary, Dr. Suri Raju, and our Senior Vice President, Dr. Marigowda, and our Public Health Subcommittee Chairman, Dr. Kagalkar, and our past President and Chairman of IMA PPS, Madhusudan Kariganur, and Dr. IMA President-elect Veerbhadraya, and Dr. Bidini Hall,
Vice President.
and Dr. Harish Delantbettu, and Dr. Ravindra Kaje, and I thank everyone who...
Dr. Bidar sir, please.
Bidinal sir, yes sir.
Yes, sir.
Bidinal sir, I
National
recognize his presence.
He mentioned.
Yes,
Yes,
sir.
Thank you, and Dr. Anuradha Paramesh, and I thank everyone who has made this meeting a successful one. Thank you, sir. Thank you very much.
Thank you, sir. Thank you, everyone. Yeah.
Thank you, Dr. Vishwas sir. Sindolimat sir. Thank you for joining
Thank
and
you.
ask question. Good question, sir.
Thank you, sir. Thank you.
Thank you, sir. Thank you.
Thank you, Kumar sir. Thank you, sir.
Okay, take care. Okay, bye.
Okay, bye. Good night, sir. Good night, sir.
Right, good night.